You're gonna have to keep it up so you can keep admitting people. There you go. So what's interesting.
Good evening, everybody. It looks like the dings of folks coming into the waiting room have stopped. I'd like to welcome you all to our office hours tonight. I know I've not met a lot of you on this list, but my name is Ken Sanchgren, and I've been the interim executive director here at the commission for about a month. And we got a few more coming in. I'll just admit them real quick. So we're hoping that by providing this opportunity this evening for commission staff to provide some information about Exhibit F, and then also providing a means for questions and discussion, we can begin to address some of the concerns that we've heard in the provider community about these new contract terms as we move from the judicial branch to the executive branch. It's also my hope that as we move forward into our commission meeting tomorrow, that you'll all be able to tune in. I believe that this item is going to be covered by our commissioners a bit tomorrow, some discussion there, and then also some discussions about the extension of 2023 to 2025 contracts as we move into our next contract cycle. So with that, I'm going to turn it over to our staff. I know that we have some PowerPoint slides prepared, and I'll let them take that away. And I hope that this will be informative and provide some of the clarification that's needed.
Good evening, my name is Ralph Edward. I'm the Chief Financial Officer here at the Commission. We're going to go around the room here quickly and themselves in their role briefly, and then we'll get started with Janet and Amy kicking off the presentation. I would ask everybody this so folks can review it later on, and others can have a chance to be here and watch it as well. Thanks for being here, and I will go to my right. You are. Steve Arndt.
Hi, I'm Amy Shaper. I'm the compliance manager. Kim Freeman, CAP operations. Yeah. Can everyone, or other OPC staff, can you hear everyone in the room?
We can hear you, but I don't know if the owl, if we're using the owl, if it's working. It's focused on Ralph only. So as you went around the room, we heard disembodied voices, but only saw Ralph.
The owl is at the top of the screen in miniature.
That's okay.
So we do have a few other people from OPDC staff in the audience as well. And I'm not going to have them introduce themselves, but they are program analysts and some of our folks in training support and development. But with that, I'll let Janet and Amy start the slideshow, and we'll.
Hi there, Jen Hart, Chief Procurement Officer for the Commission. I'd like to talk with you about the changes that we've had to our public defense attorney contracts as a result of the transition from judicial branch to executive branch. So I'll go to our slide deck. So as you know, under the judicial branch, and as of January 1st of 2025, we transitioned to executive branch. This was done by legislative action under Senate Bill 337 in 2023. As a result, our agency is now defined as a public agency. And because of that, we're subject to the public contracting code, which is 279 A, B, and C, governing public contracting. And we're also subject to review by the Office of the Attorney General and the Department of Justice. for our contracts, because they're now subject to the requirements
Okay,
for executive branch.
they're not seeing the slides.
Are you sure?
Yeah, right now we just see the gallery view. We don't see the slides up on the screen. Yep, they're up now.
Thank you. I apologize. So our contracts now have to meet a standard that they were not required to before. They have to meet legal sufficiency of legal requirements from the Department of Justice. So that our contracts could be deemed legally sufficient. Our council and the Department of Administrative Services Risk Management assisted us in developing what you have seen as Exhibit F. And those are the provisions that are required of all executive branch public agency contracts. Its purpose is only to conform it to those requirements. And as you've seen in the exhibits, they are basically a list of statutes to which OPDC, our contracts and our contractors are subject. Questions? So Exhibit F is in addition to so far what is the capacity-based attorney services contracts. There will be an Exhibit F version to hourly-based as well as case managers and other contracts because, as I mentioned, all of the executive branch contracts are subject to these statutes. So not only will the 23-25 contracts be subject through this amendment, the 25-27 will include its provisions as well. Because OPDC as an executive branch agency is now required, as are all other executive branch agencies required to include these provisions. An example of one of the provisions that we've been getting a lot of questions about surrounds indemnity, and the current contract that was executed in 2023 assigns a duty to contractor to indemnify and hold harmless the state and OPDC from liability for all contractors' actions under the contract. Exhibit F doesn't change that. It merely informs contractors that the Department of Justice is now our counsel. That's under statute. It wasn't a choice that we made. It's an executive branch requirement. So in order to resolve this, we understand that these are changes to our contracts. There are provisions that until we became an executive branch agency, we weren't subject to. Our agency wasn't, our contracts weren't, and our contractors weren't. 11 of the 14 provisions in Exhibit F are a direct result of becoming subject to the public contracting. The other three, two of them are constitutional and one is jurisdictional. Because the requirements are statutory in nature, the only way to be exempt from them is through legislative action. OPDC's plans are to request exemptions from the requirements, just as the Department of Justice's requirement contracts for conflict and outside counsel are exempt. Legislature, when they transitioned us to the executive branch, didn't look at that piece of it, I think, when they transitioned us over. So our contracts are not exempt from the Department of Justice contract. One other alternative would be if we were to transition back to judicial, we would no longer be considered a public agency. Contracts would no longer be considered public contracts, and so they would be subject to those terms. We're looking at the earliest that we might be able to take such an action might be for the 27-29 contracts. Because it takes a legislative bill in order to make the change, just as it did to transition this over to City Bill 387. I have put together some information in a slide deck that we'll make available that has a reference to for each, and I'll just give you an example here. For each one of the provisions in Exhibit F, I went through and identified the statute or the legislation that requires us to include that provision in the contract. For example, one of the first ones there, Section 3, is around recyclable products. As you can see there, I listed the statute, Florida Revised Statutes 279B.270, and identified the text that requires us to have it. We'll have that posted on the website, so that you can refer to that information and see what the requirement is for us and for you to comply with the statutory.
Yeah, I think we need to ask if there are any questions on that before I go into.
If you have any questions, welcome to speak up or put something in the chat.
That's just me telling them where they're doing.
Okay, we did receive some questions in advance. The first one is, what is OPDC's plan if contractors decline to sign the amendment? The deadline for the amendment is tomorrow at 5 o'clock. And we can't offer an extension without a signed Exhibit F for DOJ. So analysts will be discussing wind down next week with contractors that have not returned it. When was it decided that the agency would be recommending contract extensions? We started talking about contract extensions a few weeks ago, but we had to have DOJ approval. It has not yet been even approved by the commission. That is on the agenda for tomorrow. We still need commission approval before we can talk about extensions. The most we were allowed to have is 90 days. We've asked to extend the current contract through September 30th. So that's where we're at there. That's all I've got. Does anybody have any questions? I only have one question. I received an email from someone in the OCBLA listserv who stated the following: Oregon PLF plans will not cover any risk associated with that addendum. Can you provide us with assurances that this is not true? It's from Yamhill County.
I can give you my thoughts on it, and that is that the provisions of your of an insurance policy that would take an interpretation by PLF or whoever your authority is. I will say this much: that is that the provisions of Exhibit F are statutory in nature. One of them, for example, is the Oregon False Claims Act. That would be an act that was that contractor, an action that contractor took or didn't take. And it requires that everything that you turn into must be truthful and to the best of your knowledge accurate. a requirement that you comply with Oregon tax laws, which, there are plenty of other laws out there that require you to comply with the tax laws. So they primarily are requirements that contractor must take, either the contractor or OPDC must take. Some of them are constitutional in nature. There's a constitutional debt limitation that says that we can't, there is one of the provisions that says that we can terminate the contract if we're not allocated enough money. That is something that an action that we would have to take, but then it affects our contract. So anything that is in Exhibit F is a requirement that affects the contractor's actions. So if they are saying that they have an exclusion for contract liability, that's an interpretation of their policy that they would have to do. So I wouldn't be able to give assurances that they do or don't cover it. That's not a determination that OPDC can make.
I've got some other questions in here, Jana. Didn't OPDC receive exemptions status through DAS in March of 2025? That's a question from Shannon Wilson.
What we received approval of from the Department of Administrative Services, there's two things that we've done. One is, it's called a special procurement. And what that does is it allows us to award contracts based on the application process that we have through our website. Absent the special procurement and approval, what we would be required to do is a competitive solicitation for every contract that we have. So that, because the competitive elements of the way our contracting is required to be done, so that, for example, every category 4 attorney gets paid the same. So it's not like, you're going to negotiate a lower cost or a different state of work, because all of the criminal the category attorneys, for example, they all have the same statement of work. So there really are no competitive elements to it. So there isn't really a fair way to do contract award through a competitive solicitation. So we received approval to use what's called an alternate procurement method. So we are exempt from the competitive solicitation requirements of the code, but not from the code itself. The other exemption that we received is from the Department of Justice for legal sufficiency of every single contract and every single amendment. And the only way that we have that is we developed a model that we will use, and that some of you have seen. In fact, if you have the amendment for Exhibit F, you've seen one of the models, because everyone has the same, it's worded the same except for, your particular, name and address and that kind. So that's the other exemption that we have received, but those are the only two.
Why won't the agency add language to the title section of Amendment F to clarify that it only refers to contractors' obligations to pay individuals or entities?
I'm not clear about what that refers to.
Stacy, can you elaborate on that question in the chat? And I'm going to continue down. Why didn't OPDC or DOJ confer with the PLF? And this goes along with that. We spoke to the PLF because the addendum doesn't simply dictate that DOJ is OPDC's attorney, that we cover costs that it will not be covered. We also received information from an insurance broker that no insurance policy would cover that type of third-party liability. How is OPDC reconciling that? And is the requirement for payment statutory?
So the Department of Justice is now the state's now OPD's counsel. We don't have a choice about that. That's in ORS Chapter 180. The indemnity, the coverage applies to your obligation to indemnify and hold harmless. That's in your current contract that states that contractor will indemnify and hold harmless, OPDC, and its officers, employees, and agents against all acts of any nature whatsoever, but contractors' actions, not OPDC's, but your own actions. And so the difference that what Exhibit F brings about and notifies and informs contractor is that Department of Justice is now our counsel. And so what it says is that as part of the indemnification and holding harmless, that should the state's counsel, whether it's DOJ or our previous attorneys, whoever it should be, if we elect to assume our own defense, they have interpreted that the indemnity for any acts of any nature whatsoever includes attorney's fees, attorney costs, as part of the damages, fees, losses, and holding us harmless. The other thing that it announces is that, as with any other attorney, if we're going to represent us, just like we would any other client, we need our counsel permission. So really, Exhibit F is for a statement of intent.
Okay, we have some suggestions from Shannon Wilson regarding potential changes to Exhibit F. I'm going to try and summarize this to propose the following changes be made to accurately reflect. Oops, it's really big, sorry. OPDC's intent and current PAE policies. Number one, revise the heading of section 4 to read prompt payment requirements. Number two, capitalize contract in section 4.1. Add section 15 regarding legal defense contractors. And then there's new language in there for that. Shannon, that may be something that we have to look at later. I can't see that all on the screen at one time. And it looks like Melissa has her hand up. So Melissa.
So I was just trying to get some clarification around what I think Jana was just talking about with respect to the indemnification language. I think one of the concerns, at least for those of us that practice juvenile law, is that DOJ already represents DHS, child welfare, on an ongoing basis, and they are an adverse party in all of our cases. How is it that that DOJ would then be representing OPDC when they are already involved in that matter, typically? I think that presents a conflict of interest. And then additionally, the change in the language in the Exhibit F, while the liability was addressed in the prior contract, it seems that this expands the scope, the language in the exhibit, potentially, and it doesn't just say OPDC. It says OPDC and the state of Oregon, which encompasses more than just OPDC.
For the So the current contract says contractor shall protect, indemnify, defend, and hold harmless the OPDC and the state of Oregon from all liability, obligations, damages, losses, claims, suits, or actions of whatever nature that are related to, result from, or arise out of contractor's employees or agents' actions, decisions, work, advice, activities, or failures to act under this agreement. Notwithstanding the above, contractor has no duty to indemnify, defend, or hold harmless OPDC for its actions, decisions, work activities, or failures to act related to the agreement. So the contract, and as written.
Oh,
without-
I'm talking about the exhibit. Look at the exhibit though. If what you're saying is that it's already it's already covered in the prior in the current contract and there's no change, then why was there additional language added? That's the question.
In terms of whether it covers OPDC and the state? Is that the question?
No, the question is if you're saying that there's no change with the language in Exhibit F, then it could simply be stricken, right? The indemnification language. If it does nothing, then why is it there?
Exhibit F doesn't include indemnification, the original
Yes,
contract.
it does.
It's-
There's a line about that. There's a section about it in Exhibit F.
It says related to the indemnification in section 15.
Yes, correct. So it references and somehow changes the or adds to, I don't know what the intent is because I haven't spoken to the drafter, the language. Isn't that right?
I'm sorry, the question is,
My question is it your position that there's no change, that the Exhibit F language with respect to indemnification, where it says related to indemnification, you're saying there's no change, there's no effect to it?
I didn't say there wasn't any effect to it. Clearly, we're notifying contractors that the Department of Justice will represent OPDC and the state in these matters. But
Right. And my question is, how is that not a conflict of interest when contracted attorneys, the litigation that we engage in every day, that they already represent an adverse party? Has that been considered?
that's a question for the legislature. Because we don't get to choose. And if I had to guess, we would certainly have to ask Department of Justice. But I believe just as you would, if you had a conflict, you would probably seek conflict clause. But I understand that we're representing the state. And
I think the concern is that it's unclear, right? It's the language itself is unclear about the effect of the language. And so that's a problem.
Because that, again, it's a statute. We don't get to not do it. We don't have a choice about who represents us. I don't know if you could, you're muted.
Yeah, I'm muted. I think part of the problem is that, for one, these weren't circulated to people in advance. There's a lot of concern about it, and it would have been really helpful. It would have been really helpful if they had been circulated in advance so people could explain the concerns. PLF could have weighed in. People could have gotten advice and really understood, because it's become pretty clear based on some of the communications, at least the minimal communications that we piecemeal get copied on, that not everybody that's involved in the drafting or the amendments understands what all of us do every day. And that's concerning. What we do is very different from contracting with DOJ to represent the interests of the state. Those are very different things from representing a person whose interests are absolutely directly adverse to the state. That's all.
And thank you. I truly, I appreciate your comment. But I think that those who are best positioned to hear your concerns and do something about it is the legislature. Because again, we don't get to choose who represents us as an executive branch agency. When we were a judicial branch, part of the judicial branch, we were not represented by the Department of Justice. That's a direct result of being transitioned to the executive branch.
I'm gonna read Guy Greco's comment before we go into Shannon Wilson. She's got her hand raised. The indemnification clause only comes into play if DOJ is held liable for an action by a contractor. There is no conflict of interest because it doesn't involve a juvenile case. If attorney is negligent, the PLF pays the loss within its limits, and there is nothing to indemnify. Alan Reynoldsson, also from the same jurisdiction. He says, we do not represent OPDC, rather. OPDC pays us to represent indigent. I have heard it said that this is the same language DOJ uses when hiring its own outside counsel. Is that true?
In terms of,
Is this the same language that DOJ uses when they're hiring their outside counsel?
I'm sorry, which language are we talking about?
I'm guessing it's the indemnification language.
I know it's similar to, in fact, it was the same attorney who drafted the exhibit F, who drafted the performance contract model that DOJ uses for its contract. So, but as mentioned, it's not exactly the same because they're representing an agency versus in this case, we are representing the public. So if it is worded differently, I would imagine it's for that reason. But I can tell you that in terms of the executive branch agencies that are required to use Department of Justice and Department of Administrative approved contract models, the indemnification language is very similar. The thing that it doesn't have is the exclusion of the part where it says that notwithstanding notwithstanding the contractor has no duty to indemnify the state. It doesn't include that language, but it does require that contractor defend and hold harmless the state. And those are models that the executive branch agencies are required by statute to use.
Okay, Shannon? Got your hand raised.
Yeah, thank you. Thanks so much for having this meeting, everyone. Sorry, the text I copied and pasted and it looks very big, so that was not intentional. But my the main concern that I had with Amendment F is as it relates to, because one thing that might be different for this agency than other executive branch agencies is that we often work with other contractors that are also funded by OPDC through the PAE process and other types of services like interpretation. And so in that situation, I think it would be really helpful to clarify that when those other third-party contractors are approved for supporting our legal defense services and agreeing, their OPDC is agreeing to pay for those contractors, it doesn't make sense that they're included in this Amendment F language. They should be excluded to be in line with OPDC's PAE policies. And yeah, and that's just kind of how it works. So I'm curious if that topic, if it was ran by DOJ, that, hey, we're an agency where not only are we funding the public defense like entity, like the law firm, but we're also funding experts, interpreters, investigators, case managers, paralegal, and so everything you want under the sun as a agent that could also work with that legal defense contractor. So that's my language that I proposed, and I just would love to hear what you think about that, Chief Officer Hart and anyone else who's in the room. And then my last question was, will there be a transcript or something of this meeting, because it's a little bit difficult to hear everybody in the room when you're talking. Thank you.
Okay, Carl, you also have your hand raised.
Yes, good evening. Thank you. My question is this. I reviewed the contract that we've been functioning under for 19 months. I don't see a provision within the current contract that allows OPDC to unilaterally add an amendment or change the contract without consideration. I haven't been in law school in about 30 years, but my recollection of contract laws, there has to be consideration and discussion between the parties to change a contract. And what I'm being told is I have to sign Amendment F or else. And I don't see any provision in the current contract that allows OPDC to do that.
Understood. What you may see in Exhibit F, however, are statutory requirements. These are not provisions that are necessarily of benefit to OPDC. Rather, they are a statement of fact. They are statutes to which we became subject. We became subject, you became subject, our contracts became subject. So they primarily are a statement that of what has happened. You don't get to change it, we don't get to change it. Department of Justice doesn't get to change it. The only ones who can change it is by legislative action. So while I understand your comments, and typically were it to be something that would be of a benefit, and where we had a choice in the matter, understood.
I hear what you're saying, but that I'm sorry, I'm not following the logic there. I mean, the contract was executed between OPDC and MPD and all the other contractors in October of 2023. That's what controls. Not the fact that OPDC was moved into the executive branch and there are statutes that executive branch contracts are supposed to comply with. It was not an executive branch contract when we signed it. And it hasn't been an executive branch contract until, well, it hasn't. I mean, it's non-executive branch contract. So sorry, I'm not understanding what you're saying.
Well, the conditions have changed for both parties, not just us, but for contractors as well. And I'm not an attorney, don't play one on TV either, but I believe we don't get to selectively choose which laws we comply with if they apply to us.
Sorry, Gina Stewart, I see you have your hand raised.
So I put this question in the chat and I just wanted to go back for some clarification because in terms of the juvenile work, I often represent children who have substantial claims against the state, right? In part because of state actors. And it's my understanding of the ethical obligations and your standards that I'm required to preserve those actions to allow them potentially to recoup later on. So I'm a little bit unclear about how I then, can you help me understand that in terms of this identification? I apologize for not being able to pronounce the word. Specifically when you represent children who have been actively harmed by the state actor and have tort claims arising out of that, which are intertwined with the nature of the representation.
I will say that I don't have advice for you other than that it again is a question that we would have to ask the legislature. What was their intent in this? It's because as a judicial branch agency, we would not have been represented by what amounts to opposing counsel. But again, we don't have a choice in the matter other than to recommend that in these cases for Department of Justice that there be conflict counsel assigned. There are a number of what appear to be conflicts as a result of having been transitioned into the executive branch. And so I would just ask, in any of our contractors that if you have these concerns, that the legislature needs to know about them. They and they alone, and enact the legislation that would either remove us from the executive branch, or at the very least exempt us from some of these requirements. I said 11 of the 14 are a direct result of being subject to the public contracting code, to which virtually all other executive branch agencies are subject. One exclusion that I will note is that Department of Justice contracts such as these are exempt from the code. So at the very least, if we might have our contracts exempt from these requirements, that would resolve well, not every one of them, because, for example, one of them is about tax compliance. You don't get to get out from underneath that, but at least it's the requirement that you have to represent more and that you have been compliant for the previous 6 years.
And certainly I'm not concerned about the tax compliance component. Does OPDC have a plan to address, because the state of Oregon just settled like a multi-million-dollar lawsuit regarding issues that arose out of foster care. And I believe there are a number of other suits pending. So is there a more specific plan to address these issues moving forward within the next contract round? Because there are active issues currently.
Well, what I can say is that unless and until the legislature moves to remove these requirements from OPDC, we're statutorily required to follow them. We don't have a choice to not do it. And it only since we became January 1st, we became an executive branch agency. That was a legislative decision, and we're subject to what they require of us, just like any other executive branch agency. So I apologize that I don't have any other options. And trust me, I did ask our council. Can you think of anything that would, any other process? And the only option they gave us was legislative action, either to move the entire agency back to judicial, or to, at the very least, exempt the contracts from the public contracting. I truly understand what you're saying about the conflict. I had to question myself, but again, we're mandated by statute, and if there is an alternative that we can suggest, that we're allowed to do, perhaps that would be one way to make suggestions. But again, I would ask you that you would take your concerns to the legislature, because they need to hear what consequences of their decision and the conflict they believe it's created.
Stacy Lowe, and then I'll go back to the chat.
Thank you. So I did clarify my issue within the chat, and it was much, I think Shannon Wilson outlined it quite well. And I understand that there are statutes in play that only the legislature can change, but I do think another alternative is to look at the language and to modify the language. I think OPDC is fully capable of doing that, and that is exactly what lawyers do all the time. And so I don't know why that's not being considered, because I think there are lots of things that we can do through a language modification to not only clarify Amendment F to make the contractors feel more secure and confident that what we are being told via email and other methods that it means, we can make it say that, and it would still be fully compliant with the statutory scheme that we're working with. And it would still be fully compliant with what the intent of the language is being represented as being. And then I don't think that the agency would need to be in a position of trying to strong arm contractors into signing something that they are uncomfortable with. And I, at that point, also agree with Carl McPherson. I don't think it matters whether or not the agency directly benefits from that behavior. It is not legal behavior anyway. And I think we are all happy to sit down and talk about ways that we could modify the language and still everybody be happy with the outcome and all the compliance with the statutes. So that's all.
So the language that we can change and still be compliant refers to which of the provisions?
My specific concern is the indemnification language. I don't have the exhibit in front of me right now. I think it's 4(2). If really it is about the contractor's responsibility to pay its employees, the plumbers, you know, people and entities that is we are directly responsible for paying and doing so timely, as opposed to individuals and entities that end up being our agents for the purposes of working with us on a particular case, such as the interpreters, investigators, case managers, experts, but that OPDC has authorized payment and guaranteed payment for, you know, those are two very separate things, but it is not clear from the language that those are treated separately. And because of that, it is unclear whether or not that indemnification would leave an agency like mine holding the bag if OPDC, for example, ran out of funding to pay those entities or individuals. So simply clarifying that would solve my problem. And I think towards that end, Shannon Wilson's language is excellent.
And bringing up the exhibit F language that I believe you referred to.
Should I continue through the questions while you look?
Yeah, it's on the screen. I just need to bring it up and share it. What would it be?
Melissa said, so did OPDC not anticipate the move to the executive branch? Yes, we did. It's been threatened for a long time. And we knew some of these issues, and it was our argument back to the legislature why they shouldn't do this, Melissa. And I mean, I remember being at a conference probably 6 years ago when this first brought up. And we were like, oh, holy cow, this can't happen. And then it did. And here we are. You know, it's unfortunate in many respects that we are where we're at right now, but this is where we are. And Janice got that document open. So she's going to share that in just a second. David put something else in the chat, so I'll wait while she shares that. Does OPDC anticipate substantial additional boilerplate language being part of the new contracts after the extension period is over? Yes, if it's approved. If so, how soon will that new boilerplate model contracts be available for review by contractors? We're still working on that. Thus the reason for the extension. Our hope is that over the next month or so, maybe the next 45 days, we will be having, more of these meetings to discuss the language coming out, David. Can everybody see that? Okay, good.
So here's the, I believe the language that you were talking about paying contractors. This language is a direct cite of 279B, I believe it's 230, it's either 235 or 270. It is a direct quote from the statute. And again, as it's a direct result of being subject to the public contracting code 279B, 279A, B, and C. This is a from the statute. Having to do with making prompt payments, permitting liens or claims to be filed or prosecuted against and paying to the Department of Revenue all the sums withheld. And ORS 316 is the tax code. So we don't have a lot of flexibility. Actually, we don't have any flexibility as to what the statute says and what it requires. This is really a statement of what the statute says.
Yeah, Janet, this is Shannon Wilson. That's why I think I proposed to add, to clarify that the provision is required by ORS 279B .220. I think that adds a lot of clarity. And I understand where you're coming from. But the rest of the, yeah, sorry, I don't know if you can hear me, but.
And actually, each one of these has a statutory requirement around it. Some of them identify what the statute question is. So like this one, the pay equity, it actually is which the statute it is. And if, when you see the PDF of the slide deck, you'll see that and afterward I put a direct reference. So that for each section, there's a reference to, so 11 of the 14 have public contracting code requirements, and there's 2 of them that are constitutional among this jurisdiction. So you'll see that in the slide deck. And so what I did was to reference the section and then pull a quote or a quote from the actual statute that says what its requirements are. In most instances, not all of them, because some of them are kind of lengthy. But most of them are, as with this one, is a direct quote from the statute.
So Shannon's proposal to section 4 is to add language that will offer clarity as it relates to third-party contracted services authorized by OPDC through the PAE process. That would be her proposed change.
Question about that. So my understanding of PAE, the pre-authorized expenses, is that contractors invoice us directly, do they not? Because when we go through that process and we have a request to make sure that we'll pre-authorize. My understanding is that we don't then go through the process of amending the contract to add that so that they act as your subcontract and they would bill you and then you bill us. My understanding is that they bill us directly.
That's correct.
If that is the case, those are not actions under the contract. And if you look at your indemnity clause, it says for contractors' actions under this agreement. So their actions would not be, we would not indemnify against their actions because they're not ones that are provided under the contract.
Shannon, I've managed to work out your large font here. Her other suggestion, regarding section 15, would be to reword it to this. OPDC may approve certain other persons to work with contractor for purposes of providing legal defense services, including, without limitation, experts, interpreters, and investigators. Contractor may enter into an agreement with an OPDC approved legal defense contractor for legal defense services, with OPDC being responsible for receiving invoices from and making payment directly to the legal defense contractor for services provided under the agreement. Section 4 does not apply with respect to any legal defense contractor approved by OPDC. Shannon, are you still here
I am.
by that?
I'm sorry, can you say that one more time?
By that? Like, give me an example.
Of how this would apply?
Yeah, how would this apply? Section 15.
So what it is, it's an offering to clarify, because what's unique to us as contractors, right? The very services that we provide, when we have another approved contractor working with us, like another approved contractor through the PA process working with us, they in fact, in the legal profession, they do become our agent, right? That is how we preserve confidentiality. They are working on our behalf. And so because they're an agent of the attorney, that's the whole nature of the profession when working with other contractors. And so this adds an additional clarification that Chief Officer Hart also just mentioned. But because it's such a unique profession and other contracting an agent relationship with the attorney, it's so unique to our profession. Adding this additional language would just clarify exactly what Chief Officer Hart, and I apologize if I'm not saying your title correctly. I was trying to figure out how to say it. So, but that is what I was hoping to do, is just make sure that we are clear that it's in line with the work that we're already doing, and also like the PA process and policy, so that we're just uniform through and through and no questions about that.
Understand that. Okay, Stacy, you have your hand up.
Thank you. Yeah, I just wanted to add to what Shannon said. I agree with everything she said. And because of that, and because the work we're doing is under the contract, I think that's where the concern comes in, that this would also cover those situations, is because it is work that we are doing under this contract for the representation of these individuals, and these experts, or these individuals or entities are our agents, as Shannon pointed out. And so that is where it gets tricky, and that is where it gets concerning. Although I still am firmly of the opinion that it can all be straightened out with just utilizing some more clear language. Thank you.
Okay. We have got 1 minute left. So are there any other questions or anything that I missed in the chat?
Didn't really address David's question about the plate, or did we? You read it?
Did I miss it?
Well, I thought you read it. Did you answer it? And I just didn't. Yeah.
Oh, I kind of did. Okay. David, we're probably going to have in the next 45 days or so some more office hour meetings like this. I'm hopeful that at some point we will be creating a page on our website that we can put FAQs out. We can put the documentation out there. We can have more conversations back and forth, as opposed to ending up in this kind of situation again, where people don't have a lot of notice about this or time to kind of weigh in on it. So I am hopeful that that's what we will be doing going forward.
And we do plan to put the slide deck that has the references to the statutes that are underlying the exhibit requirements. We plan to put that on our site, as well as a link to the recording so that others so that you can rewatch it, or those who weren't able to join us can get the information as well.
Any other questions before we call it an evening?
When might we learn if this session has resulted in any changes? I'm concerned that maybe our deadline of tomorrow by 5, I'm assuming, is not going to give us a lot of time.
I imagine we will be engaged in a conversation here very shortly. And I think that Ken is probably still online. And I suspect that we will be discussing this, or he will be discussing this tomorrow at the commission meeting, would be my guess.
Any other questions? Go ahead, Stacy. Go ahead.
I just wanted to say thank you.
Okay, sure. No, thank you. Last call. All right. Thank you very, very much for attending this session for us. We look forward to having some more sessions as we get more into the contracts and everything else over the next few weeks. So please look for our posting of this PowerPoint and other information. And again, as always, please feel free to contact us if you have any information or questions on something that we're doing. We'll get right back to you as soon as we can. Thanks, and we'll call it an evening. Take care, everyone.